Welcome to MLS. Lights on, mic hot, headlines full of madness, drama and lies, black robes, cold stares, truth buried in the spin, but we break it down plain so the people can see it. From motions to mistrials, the circus comes alive. Everyone's an expert, even when they're not. We cut through the noise, keep it simple, keep it real. Law books on the table now, tell me how you feel. They say tone it down, say maybe don't speak, but silence ain't justice and quiet ain't free. MLS, yeah, we making law simple, talking truth on YouTube, never soft, never gentle. They can clutch their pearls, they can hate, they can whine, but we're still hitting record every case, every time. If you don't run this town, they'll try to walk all over you. So we stand our ground, say the things they won't let through.
Hey, cuz. Heard you're having money problems.
No, you didn't.
Listen, I got the answer. You declare bankruptcy, all your problems go away.
How would that help, Creed? In Monopoly, you go bankrupt, you lose.
You don't go by Monopoly, man. That game is nuts. Nobody just picks up get-out-of-jail-free cards. Those things cost thousands.
That is a good point.
Bankruptcy, Michael, is nature's do-over. It's a fresh start. It's a clean slate.
Like the witness protection program.
Exactly.
Not at all. I declare bankruptcy!
Hey, I forgot to add myself to the screen. Hey, welcome everybody. Welcome to Making Law Simple, where I am slowly figuring out this streaming thing again. But welcome. I am David Helm, a licensed practicing attorney in the state of Michigan, and today we're going to be covering a topic I haven't covered since law school, and that is bankruptcy. For those of you who have been following along in the Laura Owens saga, you are well aware that she apparently has filed bankruptcy after getting a $150,000 judgment against her by Eckhart and probably a few other things. But today, so the last couple of days, I've been streaming on the weekends, and we've been talking about Laura Owens a little bit, namely her going after a YouTuber and how that's probably going to fail spectacularly. And then people were telling me that I need to check out her bankruptcy hearing. And so that's what we're going to be doing today. Perfect clip. I thought so. Whenever I hear bankruptcy, I always think of Michael Scott. And so I love that clip. But welcome everybody. Welcome. We have it pulled up. We are ready to go. I did give whatever something Ninja, whatever their channel is. Hopefully they're cool with me playing this. I did give them a shout out in the channel description. If you want to see this entirely without my commentary, then check out their channel. It is linked in the description. So there's two hearings, and this is essentially a creditor's exam. It's a meeting of the creditors, but it's an opportunity to ask the debtor some questions about her finances. And this one, so there's two of them. One is fairly short. It's only like 12 minutes, but it starts on January 12th. How long is it? Yeah, it's like 12 minutes long exactly. I'm not sure why it continued. I was told not to listen to this ahead of time by somebody in chat. I can't remember who. And I promised I wouldn't. So now we're going to listen to it for the first time. Yeah, however you say that, Ninja is awesome. Yes. Buckle up, Julio says. All right, I will buckle up. And then we have another hearing from February 9th, which I think gets a little bit more involved because that's 43 minutes long. So we'll listen. We'll see how this goes. The February 9th one is Golden, Platinum, Wonderful. All right. Looking forward to it. Was it you who told me? You told me not to listen to it? Mary Smith, it sounds like you. I can't remember who told me not to listen to it. But I didn't. I only, just for a few seconds, popped around just to make sure that everything was working properly on these links and that we weren't going to have an issue. But I don't know the substance of it. The January 9th one is the one I meant to send. Oh, February 9th. I'm sorry. Yeah, well, we have the January 12th one, which I'm going to listen to too, because it's here and we're going to listen to it. But I also have the February 9th. It's ready to go. We're just going to listen to this one first, since it came in order. Unless there's others that I don't know about. But I do have both. I have both of them, and we're going to listen. I am up against the clock a little bit. If you notice, I started the stream a little bit later than normal, or than not normal, a little bit later than I had planned. I'm going to play this at 1.5, but if it becomes a problem, then I'll slow it down. But I want to make sure I have time to get through all of it today. Stop bullying this poor woman. I'm not bullying anybody. Excited. I see you're going live in 30 minutes too, by the way.
The Laura Owens case 25-11801.
Let me know if it's too loud for anybody. That was loud in my ears. My headphones are turned down too. So what I have my audio booster on. All right, I'm going to turn my audio booster off, and let me know if it's too quiet for any of you all.
Debtor is present. We have a lot of interest. I keep having people.
Thank you very much for becoming a member of Making Law Simple. We're going to do some membership streams here.
Pop in. No, I think that's a. Let me check.
And excited utterance with the gifted 5 members. They went to Boost Scott, Julie O, Mary Smith, welcome. Just Jen, the Crushing Couple, which sounds dirty in all the right ways. You all got gifted memberships thanks to Excited Utterance, so thanks her. Wait, there we go. How is this not? Why? Stop. What am I trying to do? Okay, there we go. All right, let's get this going.
Another debtor. I'm not going to let that person in. We have enough in here. We have a lot of interested parties in the meeting, but as far as I know, we're only going to have one ask any questions. So I'm going to go ahead and swear you in, Ms. Owens, and we're going to let this creditor's attorney. Actually, let me. What is your? I have your name, sir. What is? And I'm sorry. I think is it Eckert? You're representing.
Never. Right. I will never get.
Ms. Owens, would you raise your right hand for me, please? Do you solemnly swear the test? Okay, this happened before. I don't know who. Somebody.
Is this somebody pranking or like what's going on? I've been messing with the settings. I want to go back. All right, hang on. We're gonna start this all over again. All right, fresh start here. I want to listen to this. We're at like a normal speed now.
All right, this is a call on the Laura Owens case 25-11801. Debtor is present. We have a lot of interest. I keep having people pop in. No, I think that's a. Let me check. That's another debtor. I'm not going to let that person in. We have enough in here. We have a lot of interested parties in the meeting, but as far as I know, we're only going to have one.
By the way, the last time I practiced bankruptcy law, I didn't really practice it. I would just substitute in for bankruptcy attorneys. So I'm well aware of these conferences, but when we used to do it, it was all in person. I've never done it since like post-COVID. The fact that they have a bunch of debtors in one Zoom room is very interesting to me. And probably the reason why this was cut short, now that I'm thinking about it. And then they probably brought her back for separate. Like, we're just going to bring back this one debtor because obviously we got some issues here.
Ask any questions. So I'm going to go ahead and swear you in, Ms. Owens, and we're going to let this creditor's attorney. Actually, let me. What is your? I have your name, sir. What is? And I'm sorry. I think is it Eckert? You're representing. Eckert. All right, Ms. Owens, would you raise your right hand for me, please? Do you solemnly swear the test? Okay, this happened before. I don't know who. There's noise bleeding through somebody, and it's probably somebody on the phone. If you can't mute,
even in the prestige of the federal bankruptcy court, we get the same shenanigans we find in district court with random people talking and popping in and out. It's probably smoking and engaging in coitus at the same time.
Your device. I'm going to have to remove you from the meeting.
Yes, he's an idiot with zero common sense and no social skills.
Sounds like someone's watching TV.
He'd be a disaster. Asterisk has been widely debunked by fact checkers. Source. The quote first appeared in 29.
He's not watching TV because they said asterisk, which means like it's doing like an audio reading from like a document or something.
19 as a social media.
Members not muted as Patrick. All right, who do we have? Who is it?
Patrick. Patrick is not muted.
It's not coming through. As who's doing the?
Patrick lives in infamy now.
There is no record of it appearing in any press coverage during her lifetime. Common pattern. Similar fabricated quotes have been attributed to the mothers of other world leaders, such as formerly King
Patrick O'Connor. Who's that? That's you, sir.
Other family members.
Okay. I had to mute Mr. O'Connor. All right. I'm sorry, Ms. Owens. Please, if we can continue. Raise your right hand, please. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Would you state your full name for the record, please?
Laura Michelle Owens.
Okay. So I'm going to continue to work with the debtor. I still need to get some documents so that I can ask my questions in a meaningful way. But because of the creditor interest in this, I'm going to open this up and ask, are there any parties in the meeting who wish to examine this debtor? Go ahead and make your appearance, sir, and tell me who you represent since we're on the record now.
Yes, Marcus Reisinger, appearing on behalf of Clayton Eckert, a creditor in this matter. I'd like to ask a few questions.
All right. Thank you, sir. Go ahead and please be mindful of our time constraints.
Understood. Ms. Owens, have you been advised of your Fifth Amendment right to remain silent?
No, I have not. I don't have an attorney in this matter.
All right. In your bankruptcy petition, you filled out what's known as Form 107, which is an income statement. Do you recall doing that?
Yes.
Yeah, and page 2 of that statement asks, did you have any income during this year?
Okay, it's never good when the attorney asking you questions advises you of your right to remain silent. You at that point, you should be asking yourself, why is he asking me this? I hear this in cop movies, and it's usually when they arrest the bad guy. Why is he asking me this? Doesn't cross her mind, though.
For the 2 previous calendar years, why did you answer no?
Because I personally do not have any income and have not for the last 2 years.
Did you testify in June of 2024 that you had approximately $200,000 per year of income with your business partner?
With my mother, and that's all gone directly to the LLC. Nothing's been paid to me personally.
So is it your testimony that you received no income from any of the LLCs that you listed in your petition?
Correct.
Okay, so here's the thing. An LLC is a limited liability company, which means that the liability, contracts, things like that, sometimes employment-related matters, all stop with the company. But the tax liability passes through to the owner. And so if there's 2 owners, any profit generated by the LLC is considered income for the 2 owners. So at least half of the proceeds or the profit from the company is her income. Whether she wants to say, I didn't draw on it or not, for tax purposes, it's her income.
In March or April of 2024, you stated in an affidavit that you had $450,000 in cash in an account. Where's that money now?
As Mr. Eckert knows, that was never my money. That was an investor's money. He was going to provide the down payment for the house as I was looking out with him. He spoke to that investor, and he knows that.
Where's that money now?
It didn't belong to me. It was an investor's account. It was an investor's account. He was an investor who was going to provide me the down payment. I have no idea what the guy has done with the money.
Wait a minute. Let's pay attention to the chat, not listen to this. She has investors' money that went for a down payment on what? Hang on.
In March or April of 2024, you stated in an affidavit that you had $450,000 in cash in an account. Where's that money now?
As Mr. Eckert knows, that was never my money. That was an investor's money. He was going to provide the down payment for the house as I was looking out with him. He spoke to that investor, and he knows that.
The house that... Whose house? Anyone know whose house this is?
Where's that money now?
It didn't belong to me. It was an investor's account. It was an investor's account. He was an investor who was going to provide me the down payment. I have no idea what the guy has done with the money.
When you represented that the money in that account belonged to you, were you not telling the truth?
I did not represent that money belonged to me.
What is Liz Max Investments LLC?
It's my mom's LLC.
Do you currently have an interest in that LLC?
I do not.
Have you had an interest?
So there's an investment LLC. Who knows what they're investing in? It could be real estate, could be anything else. She's not an interested party in that. But there is $450,000 of investors' money that apparently she's hanging on to, may or may not be claiming is hers, but is now claiming that it's not.
In that LLC in the past?
I started that LLC with my mother. We purchased one home together through Liz Mack's LLC, and that money was only provided by my mother. The down payment was provided by her own personal funds.
Okay. So first, she's not in business with her mother in that account. That's her, or that business. That's only her mother's business. But then she states that she started it with her mom, which could be true, right? If there's letters of organization and then her mom buys her out, that could all be true. But then why is there $450,000 from an investor?
At one point in time, you did have an interest in that LLC?
I was listed on the LLC. I was never paid out of that LLC.
But you did have an interest, correct?
I don't even understand legally what it would mean to have an interest, since I never made money from it and never provided money into.
Is she dumb, or does she not understand? Now, I have a feeling it could be both, because a lot of people don't understand what they're getting themselves into when they form LLCs, especially with other people, and what the tax consequences and the ownership is. But I have a feeling she's playing dumb.
The account. I mean, anyone can start an LLC in the state. That doesn't mean they're making money from it.
All I'm asking is if you had an interest in the LLC.
I truly, as a non-lawyer, do not understand what it would mean to have an interest in the LLC if I'm not making any money from it or providing money. There's nothing financially to do with anything.
Okay. Do you recall when you transferred your interest in Liz Max?
Again, like I said, I think it was March of 24. There was an issue with the paperwork that it didn't get recorded until 24 that my name was taken, or until July, I believe, of 24 that my name was taken off of it, but the paper was filed with the county like in March of 24, and they can.
So in March of 24, now, if I'm not mistaken, there's at least a 3-year look back for bankruptcy proceedings, which means that if she transferred assets out of her name within the last 3 years of her filing this, they can claw that back and put it into the bankruptcy proceedings. And that's why they're asking all of these questions. Keep in mind that most of what she says is a lie. See, I don't think that last statement she said was a lie. I think it probably was transferred out of her name in May or whatever she said of 2024. But that doesn't help her. She thinks it does, but it doesn't.
They would be able to state that I submitted it incorrectly.
All right. You also listed an interest in your petition in a company called Keybacker Incorporated. What is that?
Keybacker was an idea for a company that I had that never got off the ground.
Do you have a current interest in that company?
No, I mean, it doesn't operate. I don't believe it's current or has been.
You also listed one called Stylet LLC. I may not be pronouncing that correctly.
Yeah, that's another one that never got off the ground.
Do you have a current interest in Stylet?
Again, I don't think that's current either.
Okay. The last one you listed is called Quartet Farms LLC. What is that?
That's a business that my mom started herself in December of 2014 for horses.
Do you currently have an interest in Quartet Farms?
I do not.
Does Quartet Farms have any valuable assets?
Quartet Farms has if you want to consider it valuable, a 20-year-old show horse and 7 horses who are in their late 20s.
Hey, $500 each.
Horses that were never paid for by me ever in my life, and nothing would be able to be tracked to me because nothing was paid for by me. I have no assets. I know what you guys are getting at. I have literally 0 assets.
I'm just asking some questions so I can understand your mistake.
I don't have one. As you know, this case is demonstrating my ability to make any income. I have none, and I truly believe you guys are trying to embarrass me by trying to make that point.
Again, I'm not trying to embarrass you.
See, you can't file bankruptcy and then expect people not to ask you questions about your finances. That's the nature of bankruptcy. She filed improper, if I'm not mistaken, right? And then, oh yeah, I heard David G wants to file for limited purposes. I read through that motion. I'm not going to talk about it because it's fairly short and inconsequential. But man, hey, Dave G, if the court rules don't allow limited purpose or limited scope appearances, then you can't do it, man. What you're trying to ask the court to do is change the rules through one particular case. They're not going to do that. Lobby the bankruptcy court to say, hey, over here in Arizona, we have limited appearances. Why don't we allow that in federal courts? You can't, and the way he's doing it too is very interesting. He wants to do it in limited time, not subject, which is interesting because most of the time when people are filing limited appearances, it's just for a specific like subject matter or legal issue, not necessarily in scope of time. So it's very weird to ask for limited appearance only for, what do they say, 30 days or 60 days to just complete discovery. It was weird. It's a weird motion. Wendy says, thanks for streaming for $9.99. Thank you for being here, Wendy. And sorry we had to cancel the Lego stream. For those of you who don't know, I do have a Lego Law, Life, and Libations channel where we interview various people and while we build Lego. And we had one planned for this evening, but it just had to get canceled. I was going to redirect you all there. But we'll do it maybe tomorrow. And then Wendy can jump on with me and Lagoon. So I just got a message that Lagoon is not available, so we have to do it another day.
I'm doing is asking questions to understand your bankruptcy estate. Do you currently own any horses?
No, I don't.
Have you listed or sold any horses in the past 2 years?
No, I have not.
She doesn't own any horses, but she owns an LLC that owns horses.
Have you competed with any horses in the past 2 years?
Yes, I have.
Have you sold any equipment or supplies for horses or for equine sports in the last 2 years?
That are owned by my family's LLC. Yes, I've never paid for anything.
Okay, so you listed and sold the property for the LLC?
There was a 15-year-old saddle. I don't know if that's what you're trying to get at, but
well, I don't know what I'm trying to get at because I don't know what you've sold. That's why I'm asking you the question. Have you sold?
That's what I sold. That's all I've sold of any value.
In the summer of 2024, you were removed as a member of Cortec Farms LLC. Do you recall why?
It was an issue. I think are you talking about with the United States Equestrian Federation?
I'm talking about Cortec Farms LLC.
With the United States Equestrian Federation?
Articles of organization were amended and you were removed as a member.
Well, we didn't know I was ever listed as a member, or I didn't know. My mom had at some point, I believe, put me on there since I was providing expertise in terms.
I never knew I was a listed member. I believe my mom at some point put me on there. Those two things conflate with each other.
In terms of horses, but again, it wasn't like I've been getting paid. I've never been paid a cent out of it.
So, last question. Your testimony is that you have not had any income in the past 2 years?
No, I have not.
And you understand that you're under oath?
Tell me where the money is then. I haven't made any money.
The only reason I'm asking is because you did testify numerous occasions in 2024 that you had income at that time. Is that correct?
That I had businesses with my mom.
And that was less than 2 years ago, correct?
That I had businesses with my mom. My expenses have been paid for living by my parents. That's what I've gotten in exchange.
All right, Mr. Haley, I think that's about as far as we need to go today. We may notice at the 2004 examination.
Okay, thank you. I think the answer to this is no, but I'm going to just ask again, are there any other parties who want to examine anyone in this case? No parties appearing. I need Ms. Owens, I need to get some information from you. So please follow up with that email, and I will reply with a PDF copy of the letter that I sent you earlier. But we're gonna redo this and continue it to February 9th, 2025, and that'll be at 1 p.m.
Is she crying?
So,
Okay.
Ms. Owens, I don't think, hopefully you wrote that down. I don't think another notice is going to go out. It will be
February 9th at, you said 1 p.m.
1 p.m. and you'll
Not
connect the
crying
same
anymore.
way that you did this time. So it will be on your docket, but I don't know that another notice is going to go out. So February 9th, 2025, or 20, did I say 2025? That's obviously not right. February 9th, 2026 at 1 p.m. All right. You are free to go, ma'am. Thank you. And thank everybody for their time.
All right. That is all for that one. Now we're going to go to the February 9th. But first, I want to answer a question or two. Half Irish wants to know, what are the consequences is she facing if, when caught lying? Perjury charges. And not just state level perjury charges, because she's lying in federal court. She could receive federal perjury charges. Yay! We're advancing our career. That's her likely outcome if she's found to be perjuring herself. Now, She answered those questions, though, I will say, in just the right way to be excusably dumb. And what I mean by that is she says, I didn't say, or I don't have income. I simply have ownership interest in the business. And a lot of people either intentionally don't understand the difference or legitimately don't understand the difference. And it's plausible that people legitimately, or at least some people legitimately don't understand the difference. Like if you have a company, an LLC, mind you, not a corporation, an LLC, and that LLC receives money, and then it pays its expenses. But at the end of the day, if it has a profit, that is deemed income to you, the owner of the LLC, whether you take a draw on it or not. So there are different circumstances in which it won't be considered income. But for the most part, just assume it is going to be considered income. And at least it's an asset of yours, right? And we're in Chapter 7 bankruptcy, which means all of your assets get liquidated. So if it's a profitable company, half of that profitable company is going to have to be liquidated in some way, shape, or form. That's the problem here. I don't think she really quite understands that. My name might be on it, but I didn't draw any money from it. That doesn't matter. It's an asset of yours that has value, especially if it owns 7 horses, even if they're 20 years old. I have a 25-year-old horse that I could at least get $500 from. Let's see. It's wild how angry she gets when people push back or answer questions. Very entitled. Yeah, she's very entitled. You get that sense when you watch the police body cam when she's at her parents' house. That she's very entitled. Let's see here. Let's figure out where we are here. It's gross income for bankruptcy purposes. It is gross income for bankruptcy purposes. The other thing too is that they can start going through your businesses to some extent to see if you're fraudulently transferring things, such as horses. If you're fraudulently transferring assets away from the businesses that you own, they could again claw those back, or at least the value of those. She's putting a lot of people in a position here. Let's see. MLS is horse property. Is a horse property like a dog? Yes. Yeah, a horse is property like a dog, I guess. But they're generally more valuable than dogs, especially if they're of breeding stock or if they're competitors that have won money in the past and things like that. They could be a lot more valuable. They could also be a lot less expensive than a dog, depending on how old it is and what it is. Transferring right after judgment against her in civil case. So that's interesting because at least in Michigan, I want to speak for Michigan, we have a fraudulent transfer act, which says that if you are transferring assets out of your name and you're doing so to avoid a judgment or a potential judgment, then those assets can be clawed back and actually attached. So let's say you own a house outright, it's free and clear asset, and it's looking like you're going to have a judgment against you. And you sell that asset with the intent to avoid collections, or like you transfer it to your spouse or something like that. That can be clawed back at times. Now, there's a lot of hoops you have to jump through and things like that. But there are state law mechanisms that could help you with that. I don't know how that works exactly in bankruptcy. But let's see what other assets she might have, because this is the February 9th hearing. Let's see. In the June 2024 hearing that Marcus referenced, Gingrich asked her if she ended up purchasing real estate, and she declared under oath that she did. Yeah. You can't be talking out of both sides of your mouth when it comes to testimony on the record under oath. Just makes for a really bad outcome. Let's see. One hand, she uses the horse as collateral, but BK claims that they are worthless. Yeah, I mean, that's the thing. You can't be doing that because it's just not going to jive. And the bankruptcy court's not going to put up with it. But this is let's see where this goes. All right, so we're continuing now. We have a meeting of the creditors again in bankruptcy court. Hey, potentially criminal Sean with the $5. Is Gingrich still in this case? There's another lawsuit where I came across him. So he filed a motion for limited appearance in this bankruptcy case, Sean. I read it the other day. I just to myself, I didn't stream it, but he did ask to appear limitedly just to get her through discovery in this case. There's, of course, a lot of rumors speculating as to why he would do such a thing. And I was told earlier in this stream that after I hear February 9th's creditors meeting that I will know why. But he is sort of kind of involved. Oh, I know what you're talking about. He filed the response to Hey-Rob's motion. So if you know Hey-Rob, Sean, he's a YouTuber that's been covering this case. He was he was served with a anti-harassment personal protection order sort of thing, and him and his attorney filed a motion to quash that because it's nonsense, which is what it is. And then Gingrich responded. I read through that on yesterday. Was it yesterday? I read through that yesterday. No, Saturday I read through that. Nonsense. He's spewing nonsense. He's inappropriately citing unpublished cases, not attaching them to the brief, making flowery arguments, for the lack of a better term. Nonsense. But welcome, Sean. Glad you're here. Now it gets good, I am told. Now it gets good. All right. Let's see. He helped start a lawsuit over copyright involved 3D printed gun parts. Who did that? Farrell, good to see you here. By the way, thank you for ignoring me in Discord. All right, let's get going on this.
It's Laura Owens, case 25-11801. I'm sorry, if you don't mind, I have to swear you in again. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Would you state your full name for the record, please?
Laura Michelle Owens.
Ms. Owens, do you understand the importance of the oath you just took?
Yes.
Is your address correct as it's listed in your petition?
Yes.
Is that where you currently reside?
Yes.
Did you receive the bankruptcy information sheet I sent out?
Yes.
Had you lived in Arizona at least 2 years before you filed this case?
Yes.
In the past 8 years, have you filed another bankruptcy case anywhere?
No.
Did you review all of your bankruptcy forms and paperwork before you filed it?
Yes.
When it came time to sign any of those documents, did you physically sign them yourself?
Yes.
Do you understand that you signed those documents under oath?
Yes.
Are all of your assets identified in your schedules?
Yes.
Are all of your creditors listed there?
Yes.
Are you paying or do you owe any child or spousal support obligations?
I do not.
Have you filed tax returns for all years up to
You don't have
2024?
kids?
Yes.
I got a 2024 tax return copy from you. What is the status of 2023s? That would have been another one that I asked for.
2023 should have been sent as well with the 24. I know my civil attorney, David Jenkerson, been helping me. I thought he sent that one over.
Okay. Can you guys confer after we deal with the meeting today and follow up and get that to me? Make sure
Yes.
I get it. The 2024 tax return copy that I did.
So Dave G is not an attorney of record in this bankruptcy proceeding, but he is sending the creditor attorney's emails with her documents. That's putting him in an interesting position. Let's see where we go from here.
See, was that a true copy of what you filed for that tax year?
Yes.
All right.
Okay, I got to call this chatter out here. It wasn't in chat on Discord. I tagged you specifically in my post about this stream and asked you when you were working to make sure that I scheduled this around your work schedule as you requested.
In the past year, have you made any payments to any family members or friends?
No.
In the past 2 years, have you sold, given away, or otherwise transferred anything?
Yes.
Okay, and you answered yes to that on my trustee questionnaire. I don't remember seeing anything about that in your statement of financial affairs, but what are you talking about when you say yes to that answer, to that question?
Yeah, I started an LLC called ListMax Investments LLC.
Okay.
And
Wait, didn't she say that she started it with her mom and that her mom owns it now? Wasn't that what she just testified to like a week prior?
it was supposed to be for investment properties, and my mom ended up being the one who provided the down payment for a property, and she ran it herself. It wasn't something I ended up having anything to do with, so I
but it's
gave
your
her the LLC.
company.
I just took my name off of it.
Okay, and if I we've already done some preliminary work in here, and if I understand it, and correct me if I'm wrong, the real estate that was the investment in that LLC the LLC no longer has it. The bank took it back.
Yeah, it was forfeited.
Okay. Is that the only transfer that you?
It was forfeited. You didn't pay the bill, and the bank foreclosed on it. Yeah, we forfeited it.
That you made to any insiders, family members, friends?
Yes.
Or rather, that was the question. Was that? I'll ask it again. In the past 2 years, have you sold, given away, or otherwise transferred anything? So that's it. Whether it's an insider or not, that's the only thing you've transferred in the past 2 years?
Yes.
In the past 3 years, have you been a plaintiff in any personal injury litigation or some other kind of claim settlement?
Not personal injury. Nothing I would be entitled to money in.
Do you have any claims like that available to you that you've not begun to pursue yet for whatever reason?
No.
No, it was owner
Do you
finance.
currently have any ownership interest in real estate, whether it's through another entity or personally yourself?
Wait a minute. Was this the same? Was this the same property that there was an investor that posted $450,000 for? And if so, how was an investor involved? If it was seller financed, where's that investor's share? And then they just walked away from the money. I don't get it. I guess I have more questions about this. I'd like to see the documents.
Anywhere?
No.
Are you the beneficiary in any trust or other kind of an estate?
No.
Have you gotten a divorce in the past 2 years?
No.
Okay. I don't have any other questions, and I'm going to open this up. But I don't think, based on the last meeting, that most of these people want to ask any questions. But I see Ms. Jaimo from the UST is here, and I'll give her the right of first refusal. Did you want to ask any questions,
names.
Ms. Jaimo?
Yes, Mr. Nelly, do you mind if I have, maybe it's 10 minutes? Is that too long?
That's fine. This is the last one of the day.
Okay.
They put it there on
Ms.
purpose.
Owens, I'm an attorney with the U.S. Department of Justice, the U.S. Trustee's Office, and we oversee these bankruptcy cases sort of as a watchdog. And I had gone through your bankruptcy documents, and I just want to ask you some questions about some of them. But before I do, I just want to make sure. So is Mr. Gringas that's on here, is that your attorney for the bankruptcy case?
He has been helping with the adversary proceeding, but he's not my bankruptcy attorney. No, I have a pro se, but he helped me because I confused some of the filings.
I can clarify that if you need me to answer.
Yeah, yes, please.
So there's an adversary proceeding that's attached to this. I represent Ms. Owens in the adversary proceeding, but only that, not in this main bankruptcy case. I'm obviously involved in the.
Wait a minute. Is that Dave Gingers? Or how you pronounce his name? He's in on. Why is he in on this call?
He has been helping with the adversary proceeding, but he's not my bankruptcy attorney. No, I have a pro se, but he helped me because I confused some of the filings.
I can clarify that if you need me to answer.
Yeah, yes, please.
So there's an adversary proceeding that's attached to this. I represent Ms. Owens in the adversary proceeding, but only that, not in this main bankruptcy case. I'm obviously involved in the adversary part of it, and I've been communicating with Mr. Haley and his counsel as well. But I've not appeared for Laura in the bankruptcy, and I don't intend to if I don't have to. But I'm just on standby for now.
Okay, so Ms. Owens, I'm probably going to end up after this.
On standby. On standby for what? You're not the attorney of record.
Noticing your deposition and formally asking you for documents. So that's something I should ask of you personally because you don't have an attorney, correct?
Yes.
Okay. So I want to start with, I see that recently you amended the schedules of your assets to include a couple of Bank of America's accounts and an E-Trade account. Is that correct?
Correct. I listed them in the wrong spot on my filing.
Okay. So what had prompted you to file the amendment? Were you just going over them and realized, oh, this was not in the correct place?
I believe that Mr. Tate had questions. He was assisting Mr. Haley, and he had questions. And so then David had helped me with making sure everything was in the right spot. So I guess, in re-amending the schedule.
Ms. Jaimo, I think you might mean Terry Dake.
Yes.
Oh, I'm so sorry.
Okay,
I'm so sorry. Yes.
You said Tate. I just wanted to make it clear. Okay.
Yes. Sorry about that.
Okay. So having seen that you amended the statements to identify those accounts, do you have copies or can you easily get?
You know what? That's probably a fair assessment. That there's little evidence that she's hiding anything. She probably just doesn't have it in the first place. But she has more than nothing. Also, gifts from family members is income for the purposes of this bankruptcy. So when she says, I've heard rumors, right? I haven't heard it. But when she says, I don't have any earnings, I haven't earned anything, I don't have a job, and I live with my parents, that living with your parents is part of your income.
Copies, like electronic copies of the bank account statements for the Bank of America account and the E-Trade account for 2025 and 2024?
Yeah. Mhm.
Okay, are those accounts still open?
The E-Trade one is that I think is the same as Morgan Stanley. I think it is. Is that I think Morgan Stanley owns E-Trade. I think that's what it should be listed under. Do you see that? It's like
I'm just looking at your schedules and it indicates E-Trade account.
Okay, then that's what I'm thinking of for the Morgan Stanley. I don't have like another. I know that's confusing what I just said, but I definitely do not have another bank account that's not listed. The E-Trade account. What was your question on that? I'm sorry.
You can get copies for 2024 and 2025 of the statements.
Yes.
Okay, so that's not going to be a problem. So I'll be asking that of you in formal document request.
Yes, that's no problem. I can get that. Yeah.
Very good. And I see that you added that you have a potential tax refund of about $891 for 2025. Is that correct?
Yes, I think that was for 25.
And where did you come up with that figure? That precisely?
I did it on Credit Karma. I did like my taxes on Credit Karma, and they came up with that figure, but then I never got a refund, so I was just presuming it was.
I can shed some light on that. That's the Ms. Owens, that's the amount that's listed on the 2024 federal return that I got from you. So it's I assume it's your testimony that you never received that.
No, I did not.
Did you file that timely? You filed that 2024 return when on or before the deadline, or maybe the extension deadline, which would have been near the end of 2025?
Yes.
Okay.
So speaking about the tax returns, Ms. Owens, will you permit Mr. Haley to share copies of the tax returns that you provided him and are going to provide to him with me?
Yes, absolutely.
Okay, so Mr. Haley, you have no problem sending those to me, correct?
You know what? It's often the people that don't have an income that get the most in returns. But strangely enough, they usually get it for child tax credits. Just saying.
I do not.
All right, thank you. All right. Did you have a CPA
Had to
or
give birth to
accountant
those
or
twins.
any financial, bookkeeper, somebody assisting you with your tax returns or not?
No, I just used Credit Karma.
Okay. And I see that in your schedules.
Now, remember, I add this with the caveat that I am not a bankruptcy attorney, nor do I practice law in the state of Arizona or in the federal bankruptcy court in Arizona. But this is Arizona, right? Court sanctions are generally not dischargeable in bankruptcy. That's just what I'm looking at, the bankruptcy code. Just wanted to see if they were dischargeable in bankruptcy court. This is under Michigan law, of course. I'd have to look under Arizona law. But the general rule is that they're not discharged. So even if we go through all this rigmarole, she's not going to be able to discharge $150,000 if it is one of these that falls under the bankruptcy code is non-dischargeable.
You listed debt to Cherry Tech, and that's a lender for Innova Med Spa, correct?
Cherry Tech is a lender that I used for Botox and for like a skin firming treatment that I got. I don't know if they're with Innova Tech, but that's not what I used it for. Was pool sculpting was the one I used it for. And I would provide the name of the place that did that as well.
Okay, so you never obtained any loans from Cherry Tech based on services or products that you purchased from Innova Med Spa?
Not that I'm aware of. I mean, I've gone to a lot of places for Botox and procedures, but that.
Of course she gets Botox. I am not a tax attorney either, but, and I say this from, I've done family law for quite a while. And when we're calculating child support, gifts from family is considered income. Mainly because I know the Michigan child support formula follows very closely the Internal Revenue Code with regard to what is and what is not income. That's why I talk about, like, if you have an LLC and the LLC has profits, even if you don't draw from that, it's considered income. It's because it's considered income for real child support and tax returns purposes. So I would imagine the tax code is very similar with respect to gifts from people. And over a certain amount, I should say. But if you are not working at all and you haven't worked at all, and your entire lifestyle is living off of a particular set of people, then I would say that the gifts probably exceed that statutory minimum that's required for it to be considered income and taxable.
That's not where I think I did anything for Cherry.
Okay, so do you have documents that show, invoices, copies of that sort of thing, that will show the debt that you owe to Cherry Tech that you listed here in the schedules?
Yeah, I should.
All right, so those are also documents that I'm going to ask for in my formal document request.
This is
So,
Arizona, right?
Just be aware,
Correct me if
please
I'm
don't
wrong.
destroy any documents right now while you're in bankruptcy. It's crucial that you keep all your documents. We're going to be asking for some documents, and even if we don't ask for them, you shouldn't be destroying anything right now.
Okay, yeah, I'm not.
All right. So
Who wants to
on
bet she
Schedule I,
immediately
it indicates
destroyed
that you
stuff?
have zero income, so no income from wages or operating a business, correct?
Correct.
And so for what time period were you stating that you had no income for?
I mean, I haven't ever in my life had like a 1099 or W-2 job, but I've, really been supported by my family.
So never in your life have you
In her entire life, she's never had a 1099 or not even a job at McDonald's, Dairy Queen, nothing, ever. It's either extremely pathetic or she's lying. I'm going to go with the extremely pathetic part.
received a 1099 or a W-2 from any business, including your own businesses?
Correct, never.
Have you ever received any
By the way, it would be a K9, not a W9 that would be issued from your own LLC. But
kind of tax form like a Schedule K1 that indicates that you have a certain share of earnings from a partnership or an interest in an entity?
No, I know that the LLC, my family's LLC business taxes are filed on a Schedule C. So that's all I know.
But you are the owner of at least 4 entities that you identified in the Statement of Financial Affairs. You are an owner of at least 4 entities.
I think that I would consider it to be like 4 I was associated with. Maybe David could offer some clarification because he helped me.
yeah, why don't you just retain
question.
him?
David?
Well, let me just pipe in here. Either Mr. Gringas represents you or he does not. So I'm not comfortable with having Mr. Gringas step in.
Right? Exactly. That's what I was saying. Let's just retain him and have him represent you.
And as your counsel, so if he's not your counsel here, unfortunately, no, he cannot be, advising you on how to answer that. I guess, do you have a copy of your Statement of Financial Affairs in front of you?
I do not, but I have always thought I was the manager.
Sorry. Just to clarify, under the bankruptcy code, certain sanctions are dischargeable, others are not. So whether or not this particular sanction for filing a frivolous claim and covering Mr. Eckhart's attorney fees is dischargeable is uncertain to me. Again, I'm not a bankruptcy attorney. This is going to have to be something that they're going to work out in bankruptcy court. But that's why they're going through this.
Of LLCs, not an owner, and I have not ever filed them on my taxes or anything.
Okay, just because I want you to be aware that if you look at your own statement that you filed under oath, you check off the box that you are an owner of at least 5% of the voting or equity securities of these 4 entities: Quartet, Lizmax, Keybacker, and Stylet. So is that incorrect information that you put on there?
I thought it was if I had been known to have any identity with those, and I knew they were ones that my name has been associated with over the years, and I was trying to cover my bases in terms of listing which ones I've been a part of.
Okay, and also I looked at your link.
Another thing. If for some reason the $150,000 gets overturned in the bankruptcy or set aside discharge in bankruptcy, at least in Michigan, under the criminal penalty, there could be restitution. She could be ordered to pay Eckhart restitution, the amount of $150,000. And in that case, that's not dischargeable. That'd be under a criminal penalty. And criminal penalties are not dischargeable in bankruptcy.
Account, and it indicates on the LinkedIn account that you're an owner and executive with those entities. Is that not?
I mean, they're really not comparable. I mean, I'm trying to market myself as an entrepreneur, but it's not like I've got these businesses that are, operable.
Okay, I'm not asking yet about whether they're operating. I'm asking about whether or not you are an owner, and you hold yourself out to be an owner of these entities on your LinkedIn account and on your sworn schedules in this case. So, and now you're saying you're not an owner. You were just, I don't know what you were. So were you an owner?
Nobody knows what she is.
I mean, I'm more like, they're my family's entities, and I'm more like the face of my family's entities with those businesses, I guess.
Okay, well, we can.
That's the way I would say that. I know I'm not answering it well. I'm not trying to not be truthful. I genuinely don't know how to explain it
Okay, well then you'll have to make sure, I'm going to recommend to you that you go back over your schedules, that you sign up for penalty of perjury and make sure everything's accurate, because you have in your sworn schedule stated that you are an owner of those entities.
Okay, I will go back and reevaluate that. I'm sorry.
Okay. All right, so on Schedule I, which is where you were supposed to list your income on the bankruptcy schedules, you added a line item on 8H for family support for food and living expenses, and you put 0. So was that a mistake? Do you receive any kind of family support to pay your expenses, your monthly expenses?
They just pay them out of their money. I don't, out of my parents' pension and Social Security. They don't give me money to pay that. They pay it directly.
So what are they paying directly when you say they pay it?
She doesn't understand the difference. I think it's legitimate. I think she legitimately doesn't understand that if she is the owner of an LLC and the LLC has profits, that she has income. And I think she legitimately doesn't think that if people pay for things for her, that it's not considered income.
Well, I live on their property, so I mean, you could technically say they're paying, housing and for my food.
Okay. What about your car payments?
We share a car. They pay for my car.
Okay, so they directly, because you are the sole owner of the car.
I'm the sole owner, but they're paying for it right now.
So you don't share a car. You're the owner of the car, and mommy and daddy pay the bills.
I can't afford to make the payment.
Okay. So, that's something that you do need to specify how much it is, even if you have to come up with an estimate on Schedule I of your schedules. You have to indicate how much money they're fronting for you for your expenses.
Okay.
Complete at 0.
You think she knows?
Okay.
So you'll need to figure that out and amend Schedule I, okay?
Okay.
Okay.
I mean, this is either her having to admit her entire life is a sham. She lives with her parents. She doesn't have money. She doesn't really do anything despite this public persona she puts out. Or she has to admit that she's lying. And I don't think she wants to do either one. I have a feeling this is what we're going to hear for the rest of this, is her dodging back and forth between these two truths. One of them can only actually be the truth, and she doesn't want to admit which one.
So, and I'm assuming your parents also pay your car insurance?
Yes.
Okay, so you don't pay any bills for yourself?
No.
And you say that are you saying that you've never earned any income on your own, ever?
Correct.
Okay, how old are you?
I'm 35.
So 35 years, you have never made any income.
This is a very condescending way to ask how old she was. And this is a bit argumentative, but this isn't like a trial, right? This is just a creditor's exam. So they can get away with it a little bit. But if I was the bankruptcy trustee, I'd be keeping a watchful eye.
On your own to pay your own bills.
I mean, like I said, I'm at the base of my parents' businesses, so they've, paid my living expenses in exchange for me helping them.
Okay, so that's kind of a compensation for your services then.
I mean, they.
Oh shit! You mean I have income?
Yeah, I mean, I don't take advantage of it, but.
Well, you're providing them with services, and they're compensating you by paying your bills, is what you just said, right?
Yeah, exactly.
Well, then you better figure out how you're going to want to disclose that in these schedules, because that is a form of compensation. I would recommend that you really read through what the
She is 35 and gets her Botox regularly, because every 35-year-old woman needs her Botox, and mommy and daddy, of course, have to pay for it and all of her bills because she can't afford anything, because she doesn't have a W-2 or a 1099 job, but she might own a bunch of businesses that have income, and she might also perform services for her parents, to which they compensate her by paying for her things, including her Botox and her car and her horses.
Schedules and statements require you to disclose.
Okay.
And we'll go more into this because I'll probably have to take your deposition, but I wanted to make sure to give you an opportunity to amend anything that you were contending was just an innocent mistake. Okay, so the biggest issue I had was that, regarding this claim of yours that you don't make any income. So you are aware that on the Statement of Financial Affairs, you did not disclose receiving any income of any kind for 2023, 2024, and 2025 through the date of the bankruptcy filing. You're aware you did that, right?
Yes, I didn't understand how I was supposed to say if my expenses were being paid for.
No, not from their expenses. Right now, on the statement Yeah, on the statement of financial affairs, on items number 4 and 5, and you could take notes if you want, so you can follow up and look,
Okay.
look into this.
I don't have a pen, but I have my phone here. Sorry.
Yeah.
Which schedule is that?
So it's not the schedule, it's the statement of financial affairs.
Mhm.
And you've recently amended it, so it's items number 4 and 5. Require you to disclose all income you received, even if it was non-taxable income.
Okay.
There's 2023, 2024, and 2025 up through the date you filed the bankruptcy petition, okay?
Okay.
So I guess let me ask you, does your 2024 tax return indicate that you received any type of taxable income at all?
No, I know I was under the limit, but I just thought I had to file it anyway.
So what do you mean you were under the limit? Under the limit? Are you
For like, I know there's like some, if you make below a certain amount, you don't have to file, but I thought I did need to file anyway.
Okay, but so it wasn't zero though. So you might have been below the threshold for there to be a tax, but you did make some money. Is that what you're saying?
I mean, not to me. I mean, if you're going based on what my parents paid for, then yes, but I didn't make $1 last year.
Okay, so I've never looked at the bankruptcy form. This is presumably the form that she filled out because it's literally for a personal bankruptcy application, but it explains things. So it says, where is it? Have you filed bankruptcy? Okay. Are you a sole proprietor of any full or part-time business? A sole proprietorship is a business that you operate as an individual and is not a separate legal entity such as an LLC. Do you own any company or LLC? And da-da-da-da-da. An LLC is this. Da-da-da-da-da. It asks these questions. It explains these things. 30-day transparency waiver. It doesn't. It's not just like, are you this or are you that? It actually explains them. And then there's pages upon pages of more explanation that you get from the bankruptcy court's website, unitedstatescourts.com or .gov. It has all the instructions, form instructions. Hey, what does this mean? What does that mean? It's all spelled out for you.
I'm talking about now 2023. Let's talk about 2023.
In 23.
Yeah, put it on 2023.
It was the same situation.
Okay, well, I guess I'm a little confused because so your testimony is that in 2023, and you're saying now under oath that you made no income whatsoever in 2023. Is that what you're saying under oath right now?
I think maybe I don't quite understand what the question is because it goes back to the LLCs with my family and and just how I'm understanding the question. All I've had has been they've compensated me by paying my expenses, and so it's been the same. So nothing has changed. I just want to make sure I'm answering it correctly, but I'm not sure I am.
Okay, you were asked on the statement of financial affairs to disclose all income, whether it was taxable, that you received from employment or from operating a business or from any source really whatsoever, and that would actually include gifts. You declared zero for 2023. Is that a truthful statement? Now that you're sitting here under oath, I just need for you to tell me if that's still a truthful statement.
Are you referring to like if they gave me a certain amount of money, then is that what you're referring to? Because there's nothing like tangible like that. They didn't, say here's $10,000 and that would be income. I mean, like my bank statements will show it's not like I had anything in there.
Well, I guess I'll have to see your 2023 tax returns.
Oh yeah.
Did you declare any income at all on your 2023 tax returns?
No, not that I can recall, unless I was saying that my parents, like there was an equivalent to what they were giving me, but I don't think I did that.
Okay, so I'll follow up with that in deposition, but I do need to understand, you're saying that now, but are you aware that what you're saying right now is completely inconsistent with the testimony you gave under oath in the Owens versus Eckhart paternity case? Are you aware of that?
Yes. Are you?
Yes, I am aware that I perjured myself. This is why you were asked if you want to exercise your Fifth Amendment right to remain silent. You just admitted under oath in bankruptcy court that you lied under oath in a civil case of which you are now being criminally prosecuted for. Let's go back. This is the admission of liability from a criminal defendant who doesn't know any better.
Equivalent to what they were giving me, but I don't think I did that.
Okay, so I'll follow up with that in deposition, but I do need to understand, you're saying that now, but are are you aware that what you're saying right now is completely inconsistent with the testimony you gave under oath in the Owens versus Eckhart paternity case? Are you aware of that?
Yes. Are you referring to? Can you please explain?
More specific? Absolutely. So you were deposed in that paternity case on March 1st, 2024, correct?
Correct.
And in that deposition, you testified under oath that in 2023, you and your mother received about $83,000 of total income from the podcast. Nobody told me.
Yes, you can. You can plead the fifth. Okay, so here's the way it works. You can plead the fifth in a civil case if they're generally under advice of counsel, which Dave G is not really advising his client very well if she's still talking. However, it can be construed against your favor. What that means is that the court can then presume that the information that you give is contrary to your best interest. In a bankruptcy proceeding, she has to disclose these things or else the bankruptcy proceeding gets kicked. And I believe there's also sanctions like you can't file again for another couple of years or whatever. So if she pled the fifth and refuses to answer the questions that must be answered in order to move forward with the bankruptcy proceeding, then it should probably just be dismissed and she lose that bankruptcy protection. So she doesn't want to, but she can, absolutely, because what she just said incriminated herself and she has pending criminal cases. That's when the Fifth Amendment is appropriate, when it could lead to potential criminal liability.
Mm-hmm. You recall testifying to that? Do you recall testifying to that? Yes or no?
Yes.
Okay. So was it true when you said it then?
The podcast was making that much money, yes.
Okay. And in that testimony, you said you received half of that. So that's about a little less than $41,000.
But it was something that, our businesses have been such that we paid the expenses out of like what's been taken in. So it's gone.
So your right to Fifth Amendment protections extends beyond just your mere words. It also extends to turning over your phone, turning over documents, turning over any evidence that could be used against you. So she could say, I'm not turning these documents over. And again, then her bankruptcy case would get kicked. That would be the outcome in this particular case. And if it was in a civil case, then it would be that the evidence would be construed against you. She still has the right to do that, but she wants to power through with this bankruptcy case, knowing that she's probably just going to get a slap on the wrist criminally. She's going to get probation. She's not going to do jail time. I mean, she might actually. There's 14 counts of felonies, but they're nonviolent. She's probably not going to get much jail time, if any. But then she's also going to get the restitution, which if she gets the debt kicked in bankruptcy, she's not going to be able to kick the restitution. So she's going to have to pay some money. I think Eckhart's going to end up losing money in this. He's not going to fully be able to recover. Neither is the other guy. But she's going to get criminally penalized and have to pay something in restitution. That's my prediction for the outcome of all of this shenanigans. Probation, some restitution ordered. She's going to pay some of the civil judgment, and then the rest is going to kind of be away. And then hopefully she goes away quietly and we never hear from her again.
It's gone right out.
I understand. And so you would say that there was no net income? Is that what you're trying to say?
Yes, we had huge losses from the businesses. Yeah.
Okay. Regardless, on the statement of financial affairs, it told you to disclose all gross income, not net income. And you did not disclose that for 2023.
I'm not sure it made that in 23. I think it was like 23. In 23, I know I testified that, but I was thinking of the previous years. It definitely didn't make that.
If he did, she would have to have disclosed that. And I think as an officer of the court, especially when sitting in on this, even though he's not her attorney of record, he would too. What's interesting is I think he might actually be, if she owes him money, then he's technically a creditor too, which might conflict him out of representing her in this case, unless he's waiving any amount that she owes him. But maybe he's concerned because he's going to owe her money. I don't know. I don't know what's going on, but he could be conflicted out depending on where the money obligations are.
23.
No, you're incorrect. Let me correct you. In 2024, you testified. And the question was posed to you in 2024, how much money did you make from this podcast in 2023? And you testified under oath that in 2023, the podcast generated $83,000 of income, of which you received half. That was your testimony under
I like what I was entitled to if I needed to touch it or if I needed to do something with it. I mean, again, it comes back, I did not understand what the questions were, and I'm trying not to answer anything I don't understand.
Okay, well, again, I'm going to remind you before we meet again for a deposition that I'm going to have you come to my office here. You might want to consider going over your answers to the Statement of Financial Affairs. I don't mind that. Shut off. Hold on. Okay.
They know they have her here.
Because you're supposed to.
This is one of those, oftentimes you hear attorneys say, don't ask a question you don't already know the answer to. First of all, this is sort of a deposition type thing, and it really doesn't matter because you're there just to discover information. But it doesn't really matter what the answer is. She's screwed either way. She either lied or she has no income. She either lied or she has income. And she's just screwed either way. So we don't really care what the answer is from this attorney's standpoint.
Disclose all gross income from 2023, 2024, and 2025. Also, when you testified in your deposition on March 1st, 2024, you testified that your horse business, and I believe that's Quartet, was that what the name is?
Yeah, my parents' business is Quartet Farms. I'm the manager of it.
Yes, but you hold yourself out to be the owner of that on LinkedIn, correct?
As the manager. I mean, like I said, so much of this is just semantics, and I don't know what I'm talking about. I'm not trying to be dishonest or
Right, but you understand that what it means. There's a difference between a manager and an owner, and you use.
I didn't know that. I didn't know.
On your LinkedIn profile, you don't know.
I didn't know on my LinkedIn. I didn't know there was a difference between a manager and a member on LLCs. I didn't know what the difference was.
Right, I'm talking about your LinkedIn profile. You hold yourself out to be an owner of Quartet. Is that not true?
Correct.
Correct what? It's not true that you lied on LinkedIn? Is that correct to say you lied on LinkedIn?
I think I didn't understand what my title was, so I guess technically, but it wasn't something that I'm trying to, it wasn't like I deliberately said that. It's my family's business. I think of it as like my family's company.
All right, well, the question is, you state on your LinkedIn profile that you're an owner of Quartet. Is that true or not?
Then I guess now when I'll change my LinkedIn, I didn't understand.
Okay. So anyway, you testified on March 1st, 2024 that the horse business, Quartet, made $144,000 of income, and that was split between you and your mom. Do you recall testifying to that?
That amount was made, but probably $400,000 in losses.
Okay, that's not what I'm asking. You gotta listen to my question. I asked you, do you recall testifying that you and your mother split $144,000 of gross income that was generated from the horse business in 2023?
I mean, I don't feel like I'm answering these questions the correct way. I mean, it's just that
the only correct way, Ms. Owens,
bank account, it didn't go to me directly. Yeah.
The only correct way for you to answer is honestly. Okay, so
but that's what I'm trying to do is answer as honestly as I can. And I don't know a lot of the stuff that you're asking me the answers to because they're my family's businesses and I don't know.
Okay. Well, that is what you testified to under oath in your deposition in the attorney suit, so we'll have to deal with that later. But that is extremely at odds with what you testified to under oath in your pleadings in this case.
Correct, because I presume that was like what.
Is there a GoFundMe? Did she set up a GoFundMe, or was that Dave G that set it up?
My equivalent would be in terms of what I had done and brought in for work.
Okay. The other testimony you gave, which is actually at trial in front of a judge on June 10th, 2024, you testified in front of a judge that you were at the time of trial 2024 making $200,000 a year approximately.
So her parents set up a GoFundMe for what purpose? Like, was there a stated purpose to like help her with attorney fees or help pay off the debt? Because in theory, if one is raising money for another's benefit, the other who's receiving the benefit doesn't necessarily have control over it, and it's not necessarily her income until she receives it. Then it's her income. But if they hold on to it, it's just being held in trust, and so it's not actually considered her income or anything at the time. GoFundMe was for her father's medical expenses. Okay, well.
Do you recall that testimony?
It doesn't count then until it hits her.
Full testimony?
Like if they're using that money to pay a in-home caregiver and the in-home caregiver is Laura Owens, then once it hits Laura Owens, then it becomes her income.
At the time of trial, 2024, making $200,000 a year approximately. Do you recall that testimony?
Correct, yeah.
And now, is that true full testimony?
I'm not comfortable answering that now that I realize how much I have messed up my other answers, and I want to speak to an attorney before I.
Now after she admitted that she lied under oath during her civil deposition. Now I want to speak to an attorney. It's like the criminal that admits to unaliving the guy and then wants to talk to an attorney after the admission of guilt. Ma'am, your time to say, I want to speak to an attorney and not answer any questions was back on January, whatever, the first hearing that we met, when you were advised of your Fifth Amendment rights. I just wanted to answer this one question. Does anyone know if the LLCs were filing taxes? So LLCs are taxed through the entity to the individual. And since Laura Owens, since they're asking a lot of questions about Laura Owens owning the LLC, I would imagine it might be in her personal taxes. They talk about her tax return filings being produced, at least all but 2023, assuming it might be listed in there. If it's not listed in there, it might be listed in her parents' tax returns, which then opens up. If Laura Owens isn't listing the LLCs in her own tax returns and saying that she is an owner or a part owner, she's said many times that she was an owner but not an owner. It's in her name, but she's not an owner. She hasn't received revenue. Now it's going to open her parents' tax returns, I believe, if I'm not mistaken. And if it's not reported anywhere, that could be a problem, but that's on the IRS, not the bankruptcy court.
I'm not comfortable answering that now that I realize how much I have messed up my other answers, and I want to speak to an attorney before I answer.
I want to do over.
Because I genuinely don't know how.
She doesn't listen. I mean, I could go diving into someone's bankruptcy or tax return filings. I don't have those. I shouldn't have those. Maybe they ask about it here because we still have actually like another 20 minutes left.
Trying to explain that income has been split up in my family.
Okay, I'm just asking if at trial you testified in front of the judge that at the time you were making about $200,000 a year. And I'm just asking.
That was exactly what I thought at the time. I mean, I know what the business is generated, so.
But you didn't report that on your bankruptcy, your sworn bankruptcy.
But that's what our family's business is generated, and I have been like the face.
Someone remind me when this judgment came down against her. What year? Wasn't it last year, 2025? I might be off. I haven't been following this case. As some of you might know, I took some time off from streaming. I was just cursorily following it. Was it 2025 that she got the judgment, or that Eckhart? 2024. Okay, so in 2024, there was a judgment against her. Do we know what month that was? Just curious. June 2024. All right. So June, Julio's got the exact date. June 10th, 2024 is when that judgment was handed down. All right. So June 10th, 2024. So I'm assuming it was just a few short months prior to that she's claiming that she makes $200,000 a year. And now all of a sudden she remembers that she wasn't making that, and that she was in fact making nothing, even though she's somehow surviving and has money for horses and Botox and traveling, presumably makeup. She has a hairbrush, I imagine. Her hair looks a little wonky on my thumbnail, but she does have a hairbrush. She's existing in some way, shape, or form, yet she has no income, zero whatsoever.
So the business is doing a lot of the work, so that's why I said that amount. I mean, I still know that was consistent with what they made, and that's why I said that amount.
Okay, well, again, we'll have to go into this more in a deeper way when you come here for a deposition. So are any of the entities, well, let me just go by each one. Quartet, is that still operating?
Yes.
And is Lizmac still operating?
No, that needs to be closed officially, but
Hang on. I just want to go back. I want to see how the attorney framed this question. Because remember, if push comes to shove, they're going to be reading transcripts, right? Later courts are going to be reading transcripts of this. They're not going to be listening to the audio. And I want to hear how this attorney asked this question.
Consistent with what they made, and that's why I said that amount.
Okay, well, again, we'll have to go into this more in a deeper way when you come here for a deposition. So are any of the entities,
Oh, she said the entities. I thought she said any of your entities. And then if she immediately started answering the question, it's sort of a de facto admission.
go by each one. Quartet, is that still operating?
Yes.
And is Lizmax still operating?
No, that needs to be closed officially, but it's not. Your property's forfeited.
What about Keybacker? Is that still operating?
No.
And Stylete was never operating, correct?
So to the extent, let me try to explain this. We deal with this a lot in family law too. When we're talking about people's incomes, if they're a beneficiary of a trust and they're not the trustee, but someone else actually holds out the money for them and gives it to them as they're needed. Or I deal with this in trust disputes too sometimes. It's not theirs until it hits their bank account. So, for example, her father could die and leave $1 million in a trust estate where her mother's the trustee, and it's for the benefit of Laura Owens as she needs at the full discretion of the trustee. And so now Laura Owens is hit with a $250,000 judgment or $150,000 judgment. The trustee could decide, hey, that's not the best way to spend this trust money. And it's and no one can get at it. And it's not considered Laura's until, maybe her mom says, hey, you need $2,000 for rent. I'm going to transfer you $2,000. Then it becomes Laura's. So if we apply that same thing to the GoFundMe, just because some of it's been given to Laura doesn't mean that she's entitled to all of it or any of it, really. But it's not considered her income until she receives it. So if she did receive some of it, then that would count as her income, but only the amount that she receives when she receives it. So hopefully that clears things up.
All right, so, but Quartet, and that's the wholesaling business? Yes?
Yes.
And that's still operating?
I'm not saying,
Yes.
I was using it as an example. I'm not saying there is a trust. I was using it as an example, the setup, then that the same would apply to the GoFundMe.
And do you still work for that entity?
That entity is not doing anything actively right now.
All right, so you're saying that these businesses, these LLCs, there were no tax returns filed individually on behalf of them? Was there or no?
Lizmax, yes. The other ones, the other two you said were
Yes, if it goes straight from Ron to Laura's attorney or straight from Ron to Laura's bank that owns the note on the car, or straight from Ron to the insurance policy for her vehicle, or straight from Ron to the doctor for the Botox. It all is for the benefit of Laura and is therefore then considered income. That's kind of what the attorney was getting at earlier, and maybe she'll dive into it again later.
background slightly. Is that correct?
Yes.
No, there were no tax returns. This never got off the ground.
What about Quartet?
Quartet, my parents file on their Schedule C.
Okay. So your parents are the ones that file on their Schedule C. They have the income Quartet flow through to them on their own tax returns. Is that what you're saying?
And nobody told me LLC.
Okay. Okay. I just have three more questions. So during the paternity action in the state court, you did testify in an affidavit that you had almost $450,000 of cash in a checking account. Do you remember stating that under oath in an affidavit in the paternity suit?
That was a misunderstanding with my attorney. So I was going to buy property with the defendant on that, and he knew that I was going to be borrowing the down payment from an investor who he had spoken to using this method called the Morty method, but Clayton admitted under his deposition that he spoke to the guy, and the guy had $450,000 in a money market account, and that's the proof of funds he submitted. It was never mine, and Clayton knew it was never mine.
Okay, so are you talking about Gail Lynn Rich? Is that the investor that you're referring to?
I don't know who that is.
Well, attached to your affidavit.
It was a man named Matt Bellene. It was his mother-in-law. That could have been what her name was. That definitely could have been her name.
Okay, so because you attached a copy of this money market checking account statement to your affidavit claiming, and you admitted in your affidavit that you attached, and I'm quoting your affidavit now, I attached proof of funds to the offers, which included a current bank statement showing I had almost $450,000 in cash in my checking account as shown below, and then there's an excerpt of that money market account. That's your affidavit.
So, David was my civil attorney. That was his error, and he will explain that if you have any questions. But that
Well, I understand that, Ms. Owens, but you're the one who signed it under oath.
I didn't read it carefully enough, and as I said, claimed to post to the fact that he's the one who submitted the proof of funds. He got that information. He knew it was never mine.
Okay, so we'll explore that further too. Okay, then.
So she's throwing her attorney under the bus by saying that that was a mistake that he made. He's got to be conflicted out, right? He can't appear on her behalf if he ends up being a necessary witness. He can't appear even on a limited basis, especially for the purposes of discovery. He's now a necessary witness in this case. So that motion by Dave to appear as a limited scope attorney of record in this bankruptcy case needs to get denied. And I haven't seen a response, but that has to be the response, right? No, he can't appear because he's going to be a witness. You can't be a witness and represent a party in the same case.
What's the
I mean, if you have another question about it, I'm happy to answer for it.
Well, my question is, when you made that statement in your affidavit.
Yeah, exactly. He'll need to breach confidentiality to protect himself. So she invoked him. So it's her right to confidentiality, right? It's her attorney-client privilege. And now she just kind of opened the door for it, but it also makes him a necessary witness. Don't you agree, Sean? That she opened the door and now he's a necessary witness, so he can appear for her.
I attached proof of funds to the offers, which included a current bank statement showing I had almost $450,000 in cash in my checking account. Was that a false statement?
I didn't write that.
Yeah, but he can't appear as a limited attorney. Like I read his motion, and he wants to appear under limited scope, which by the way the rules don't allow for, but he wants an exception to the rules for some reason. Let's assume he gets it granted, right? He's going to appear as an attorney of record just for the purposes of discovery, but part of the discovery incorporates his testimony. It has to. She opened the door, and she's the one with the right. And he can't waive it. She can, and she just did by invoking him. And now he's a necessary partner or a necessary witness. Yeah, he's neck deep in it now. Yeah, he absolutely is. But he's Dave. He doesn't have to follow the rules. I know.
It's David signed it.
She just said it again.
I mean, David signed it. David was my attorney. David signed the pleading.
Well, you understand that when you sign an affidavit swearing under penalty of perjury that it's truthful, there's consequence to that. You are testing under oath and subject to penalty of perjury that is a truthful statement. Are you saying that's not truthful now?
The $450,000 was not my error. David will take that. That was not my. He signed that affidavit for me. I didn't sign that. I mean, he knew that wasn't my amount of. He knows that. I mean.
You're denying that you signed the affidavit? I have a copy of it in front of me showing your signature.
I believe David had a copy on hand of my signature, and yes.
You authorized him to sign for you, right?
Wait, so she didn't sign? Now Dave G signed for her. Okay. So many things wrong with that. First of all, I think if the attorney had asked the question differently, she would have gotten a different answer. If the attorney had asked, "Are you telling me that Dave forged your signature?" And she would have said yes. So I think the attorney asked the question wrong. Well, not wrong. Right for her position, but wrong for what I wanted to see happen. But now there are such things as agents, right? You can authorize somebody to sign on your behalf, but not on these kind of things.
The affidavit, I have a copy of it in front of me showing your signature.
I believe David had a copy on hand of my signature, and yes.
You authorized him to sign for you, right?
Yeah, I guess that would be what it is.
Well, you're not accusing him of forging your signature, are you?
No.
Okay, so the fact of the matter is you authorized him to sign attesting that this was truthful, but it turns out it's not.
I think it's.
So many very wrong things with that.
Versus Maricini lawsuit, which is currently on appeal. What's the nature of that suit?
It's a domestic violence restraining order lawsuit.
Okay, that you had filed against her, this defendant, Maricini?
Yes.
And did you seek damages, any kind of recovery in that lawsuit?
No.
It was just a restraining order?
Yeah.
Okay, and then
Wait, who's this guy? Who's this particular restraining order against? Did she? So this is February 9th. When did she file? Keep interrupting this. When did she file the case against Hayrob? Let's see. Where is Owens? My Owens file. Let's see. Response petition. Here's the injunction. When did she get this? She got this stupid ass injunction entered on January 20th. Ow. January 20th. So that was pending when this was going on. So January 20th, she got the injunction against Hayrob. So that was already pending when this February 9th ago. But she's not seeking money damages. But still.
and it says it's on appeal. Who filed an appeal?
I appealed it.
Okay, when did you file the appeal?
This is the one in California that everyone was suspecting that she was seeking leave from the court to go to California for.
I think it was like December 5th. of 2025. I'm pretty sure.
And how did you get the money to pay for an appeal, to pay for appeal attorney and all the costs associated with an appeal?
Good question.
I don't have an appellate attorney, and my fees were waived by the court because of my income.
Okay, so you haven't paid any kind of fees in connection with that appeal? No. And you are appealing a decision that denied you this restraining order?
It got dismissed because I was in the hospital and I'm on the day of the hearing. So.
This is that hearing where she didn't show, right? Wasn't there a hearing where she didn't show and it got dismissed?
Versus Gillespie lawsuit that concluded in Maricopa County.
That was a civil case that I filed.
And what was the nature of that suit? What was the claim?
Abortion coercion was the claim.
And were you
Abortion
seeking
coercion.
Damages to recover any money in that case?
I was seeking damages, and at one point I asked that they be made to a charity, to a women's charity.
Did you receive?
How do you make your money, Mom? Oh, I made it
no,
by filing a
no,
bunch of
it ended up
frivolous
getting
cases against guys and forcing them to settle.
Was it case dismissed or was there a trial?
It was, we filed a counterclaim and it was dismissed on both sides.
Somebody's got their phone call.
Yeah,
I think it's 602, whatever that number is, I can see. You can see. Somebody, please mute your phones. Thank you. I'm sorry, Miss Owens. Can you just, so basically, I just wanted to know how that was resolved. Did it go to trial? Was it dismissed? What happened with that case?
It ended up being dismissed. I think they maybe, my side and his side, he filed counterclaims, but neither of us ended up getting anything at the end of the day.
Okay. All right, that's all I have. I very much appreciate you answering my questions. And Mr. Haley, thank you for allowing me to take up so much time to ask these questions. But just to be clear, Ms. Owens, I do intend to have, I will be asking you formally for documents, which will include those bank statements. And I will be asking you to come into my office here in downtown Phoenix for a deposition. In fact, just because since you're on the line and I don't have a phone number for you, I'm not going to ask you to reveal it on this call. But can you please look up my email and send me an email so you and I can talk on the phone to schedule. I want to accommodate your schedule for when you can come in. I don't want to ask you to come in when you're not available.
Yeah, absolutely.
Okay, so it's Jennifer Giaimo. My email address is on the docket sheet.
Okay.
It's just jennifer.a.giaimo@usdoj.gov. And if you could reach out to me, we can work on a date to get you in here that's convenient to you. Okay?
It's perfect. Thank you so much. I appreciate that.
Okay, thank you very much.
Thank you, Jaima. Are there any other parties in the meeting who wish to examine this debtor?
Mr. Haley, Marcus Reisinger for Clayton Eckert. I don't have any questions, but I would, with your permission, Ms. Jamo's permission, like to attend the trial.
Absolutely.
Thank you.
All right. Oddly enough, people are still coming into the waiting room, so let me admit everybody, and then I'm going to ask again. All right, probably have a short window here while we have everybody, but are there any other parties in the meeting who wish to examine this debtor?
Mr. Haley, this is Terry Dick. I do have one quick subject.
Yes, sir, go ahead.
Ms. Owens, with respect to Quartet Farms, the Statement of Financial Affairs says.
Who's this guy? Does anyone know who this guy is, who he represents? I backed it up a little bit. Start over.
All right, probably have a short window here while we have everybody, but are there any other parties in the meeting who wish to examine this debtor?
Mr. Haley, this is Terry Dake. I do have one quick subject.
Terry.
Yes, sir. Go ahead.
Ms. Owens, with respect to Quartet Farms, the Statement of Financial Affairs says that the business is horse sales, leasing, and showing. To your knowledge, does Quartet Farms have any horses currently for lease, sale, or show?
One is he's like for lease, but it's free.
Okay, and where is that animal kept? Is that
In
your parents'
Florida.
residence? In Florida?
Yeah.
And where in Florida?
Wellington.
And who owns the property where the horse is?
I'm not sure who owns he's at like somebody's boarding barn. I'm not sure who owns it. I can get the information. I'm just not sure off the top of my
A
head.
free lease.
Okay. Other than that horse, do you know if Quartet Farms has any other assets?
Like small amounts of like tack and riding apparel, but that's it. And like old horses that are retired.
So it does have.
But there's still value to that. Like horse tack has value, even used stuff. There's a huge market for used horse tack, and old horses still have value.
Like tack and riding apparel, but that's it. And like old horses that are retired.
So it does have other horses?
Yeah, it has horses in like their late 20s.
So I'm talking
Okay.
about.
Where are those animals kept?
Those are my parents' property.
How many?
There are 7 there.
Didn't she answer these questions already? Ask and answer.
Does
I object.
Quartet Farms have a bank account?
Yes.
And are any of your bills paid from Quartet's bank account?
No.
And does any money?
So horse tack is the halters, the harnesses, the saddles, blankets for the horse, things like that. All the accoutrement that would go on or around the horse.
Come to you from Quartet Farms?
No.
And when's the last time you've seen the Schedule C for Quartet Farms?
The bridles. Those are
It was
expensive.
last
Saddles
filed
can
in
get stupid
2022.
expensive.
I believe they got extensions, so I think that would have been the last year.
Okay. When you get Mr. Haley that 23 tax return, if you could get him the last Schedule C for Quartet Farms.
Yeah, no problem.
All right, that's all I have. Thank you, Mr. Haley.
Okay, thank you.
One thing I just want to, really quick, why don't we just put it on the record?
Well, I mean, okay, to claim that you're destitute, I have no income, I have no money, Judge, and you're leasing a horse for free, like there's potential profit right there. How about you charge money?
Ms. Owens, will you just consent to Mr. Haley and Mr. Dake sharing with me all documents that you provide to them?
Oh yeah, absolutely.
Okay, because then this makes it easier, then I don't have to ask you directly.
Yeah, anything, yeah.
We'll get those over to you.
Thank you.
All right. Okay. Again, people are still coming in, but while I have a short window here, I'm going to ask one final time. Are there any parties in the meeting who wish to examine this debtor? All right. Now understand. I'll give an extra beat because I started muting people, but you're going to have to unmute if you want to talk.
Oh, someone just shout out to her.
I'm going to say for the record, there are no additional people who want to examine this debtor in this case. I've received and verified debtor's Social Security information and ID. The information matches my records. Ms. Owens, the ID and Social Security card copy that I saw from you, were those true copies of your original documents?
Yes.
All right. You are free to go then. This meeting is concluded. Thank you for your time.
Thank you.
Bye-bye.
Yeah, saddles can get stupid expensive. Just saying. So to say that there's like no value there because there's 7 old horses, a leased horse that we're giving away for free, and a saddle or other accoutrement is nonsense. So okay, so that was her hearing. Apparently there's going to be a deposition. That should be fun. They're going to keep going further and further in this. I mean, she's screwed either way. She's either a liar or she has no money. And I think it's probably the liar part. Or she's going to claim, I misunderstood the question. There we go. Let me make myself big. I misunderstood the question, Judge. I didn't realize that income meant like the money I get or the benefit that I get. She has a very poor understanding of what income is. All right. So, yeah, I can't wait. What do we know when it is? Has it been scheduled yet? She's either a liar or a liar. Yeah, old horses could be used as lesson horses for sure. Absolutely. Charge money to ride the old horse. That's not going to throw your kid off. Absolutely. Okay, so we do have the motion for leave to enter limited scope appearance. We're going to go over real quick. I originally intended to end the stream at right about now, but since I do not have a Lego stream starting at 7:30, I'm going to keep going because why not? We're here, right? Let's take a look at this thing. I didn't redact anything, and hopefully I don't have to. But this is Dave G's motion for leave to enter limited scope appearance. You know what? I say the same thing. Aaron Olivia, by the way, thank you very much for being a member for 11 months. I have avoided Owens. Now you got me hooked. I know, right? I started with one thing because she sued a YouTuber. I'm like, let me read into this. And now it's like every day I'm just talking about Laura Owens. But that's okay. It's an interesting case. But she still rattled off Schedule C from her parents' tax filings like a professional. Yeah, she knows what she wants you or what she wants to know, and she doesn't know what she doesn't want to know. Her parents have created this entire situation. I agree. And there's a bit more to it than that. We understand that you can't use any old horse, but out of 7 horses, you probably have at least 2 that would be good lesson horses. Then the other ones are companion horses, barn pets, things like that. They have value. There's one horse in my barn that injured himself on the trailer. And while he was in recovery, they brought in a little mini horse just to be a companion for him so that he wasn't in the barn while everyone else was outside alone. They rent that horse, right? So you can rent companion horses. There is money to be made off of old horses, even if they're not rideable or anything else. So just because the horse is old doesn't mean it doesn't have value. Her parents' bankruptcy. Her parents filed bankruptcy. I don't know anything about that. I love how she immediately goes to tears when confronted. Yeah, that seems to be her go-to. But it got her out of trouble so many times before. All right. Pursuant to Federal Rules of Bankruptcy, P 9029C, in Arizona Supreme Court Rule 42 ER 1.2D. I don't know what those mean. Undersigned counsel, Dave, is it Gingras? I'm going to say Gingras. Respectfully moves for an order allowing him to enter a limited scope. By the way, this was filed 3 days after the hearing we just listened to. In this matter, on behalf of the debtor, Laura Owens. There's a citation. Let's read the citation. Undersigned counsel currently represents Miss Owens in associated adversary proceedings. Is that still going on? I thought that was done. Is there an appeal? APP. So there's an appeal going on. Oh, right? Is that what this means? There's got to be an appeal going on. That's got to be what that means. All right. As this court is aware, local rules takes an all or nothing approach to appearances of counsel, which we used to have in Michigan up until a couple years ago. I.e., when a lawyer enters the appearance in a bankruptcy matter, the lawyer is ordinarily responsible for all aspects of the case until counsel withdraws or the case is closed. General appearance, why does he cite stuff? You don't need to cite it. You don't need to quote it, rather. Why does he quote stuff? General appearance, an attorney who files a debtor's bankruptcy petition or who files a notice of appearance on a debtor's behalf must represent the debtor in all matters other than advisory proceedings until the case is closed or the court enters an order approving withdrawal or substitution of counsel. Why don't you just say until the case is closed or withdraw or substitution of counsel, period, quote, or citation? Why do you have to waste paper and time making me read that? All right. Arizona state courts historically applied the same standard. When a lawyer appeared, the lawyer was responsible for the whole case until the matter concluded or the court permitted withdrawal. This was a default rule for many years. Yes, he said that in the preceding sentence. Recently, courts have begun to realize this all or nothing approach is way too harsh because it could often deprive low-income litigants of the ability to obtain counsel who may be willing to appear, but only for limited purposes. I don't know if that's really the reason, but okay, we'll run with it. For that reason, in 2003, the Arizona Supreme Court modified the rule of professional conduct to expressly permit lawyers to engage in limited scope representation. Great. That's in state courts. A lawyer may limit the scope of the represent. You don't need to quote it. You don't need to quote it. Based on this change, the Arizona rules of civil procedure were amended to expressly authorize. You already said that. You're repeating yourself. Although Arizona's state court have embraced the benefit of limited scope representation, the federal courts have not yet adopted local rules which address this beneficial practice. Despite this, Arizona's federal court routinely agree lawyers may you missed a word. Despite this, Arizona's federal courts routinely agree that lawyers may properly appear on a limited scope, even without seeking prior approval to do so. Yes, let's quote the entire section instead of just giving a citation. To see Jacobs v. Wheaton, Van Lines Incorporated, Westlaw. You're not even quoting a... We went over this, Dave G. We went over this with your response to Hayrob's motion. You can't cite unpublished cases. And you cite quoting another unpublished case. Wait, does this mean that it's cited? Is this a published case? Let me see. Is this a published case? This better be a published case. Maybe it's just a weird way of citing things. This better be a published case. Let's check your work. Hang on. It's a district court case. Let's see here. All right. So it's a district court case, which means it has no precedent. There is a court of appeals case that is published. But why don't you have the citation? 788 Fed.Appendix.425. Where's that citation? Let's see here. Okay. No, because the 2018 case that he's citing is the district court case, not the court of appeals case. The court of appeals case came out in 2019. So he's not citing the one with precedent that's published, probably because it says the opposite of what he wants it to say. But I'm just guessing because I'm not going to pay $24. All right. Here, just as Federal Civil Procedure 83 permits district courts to adopt local rules, provided they are not inconsistent with federal law, bankruptcy courts too grants the same authority to this court. As such, the court may permit a lawyer to appear on a limited scope basis if good cause exists. No, it says that the bankruptcy court can adopt its own local rules. That's what that says. Permits district courts to adopt local rules. This permits bankruptcy courts to adopt local rules. Obviously, their local rules don't allow limited scope. Wait, really? Laura's father makes $21,000 a month? Thank you for the $199, by the way. That's a lot. I thought he was retired from the radio. Is he really popular? They're replaying his clips and he has residuals? How is that possible? He already forgot how to lawyer. All right. Sorry if I'm ignoring the chat. I like to read shenanigans. Here, good cause exists to allow Okay. Bankruptcy rule. I'm going to look this up. Bankruptcy rule. I bet you this doesn't say for good cause there could be limited scope representation. I bet you this says for good cause the bankruptcy court can invoke its own local rules. Yeah, district courts can create, amend, or authorize bankruptcy judges to create local rules. Okay, so the district court can allow a bankruptcy court to create its own rules. It doesn't say anything about under good cause a bankruptcy court can admit limited scope appearances. So where are you creating this good cause? Where does this come from? Here, good cause exists to allow undersigned counsel to enter a limited scope appearance in this matter. First, it doesn't matter. It doesn't matter if you have good cause. The rules don't allow it. It'd be like there's good cause to allow this layperson to represent this party as if they were an attorney. It's like, okay, there might be good cause, and he might be a very skilled layperson. The rules just don't allow it. And until you change the rules, you can't get there. First, the undersigned is representing Miss Owens entirely pro bono. I'm trying to figure out how that would be good cause. Miss Owens is currently seeking Chapter 7 discharge from the court, and she claims substantially no non-exempt assets and no meaningful income aside from support she receives from her parents. Miss Owens currently lives at home with her parents. Okay. You're already saying this. Miss Owens is unable to pay for representation of counsel in this matter. Happens. As a sole practitioner who is familiar with the... How does this help? As a sole practitioner, that might be a negative. Do you have the proper resources and ability? Don't you have paying clients that need your attention? Are you capable of taking on this pro bono case and still able to perform for your paying clients? That's what this signals to me. Who is familiar with the history of the events which preceded this action, undersigned counsel is willing to provide some, not all the legal services, just some of the legal services to Miss Owens on a pro bono basis, but not without any pre-established limits. So he wants a limited appearance without pre-established limits. For that reason, undersigned counsel proposes to appear for Miss Owens in this matter with her informed consent under the following limitations. If leave is granted, counsel will appear for Miss Owens in this matter and will handle all aspects of the case. All aspects of the case. All aspects. When we're just saying the court allows an all or nothing approach. So we check that box. Okay. Still not sure why we're filing this motion. For a period of not more than 60 days from the date the court grants leave. Sorry, we're going to scroll back up here. Until approving withdrawal or substitution of counsel. Okay. So the court can allow you to withdraw. See, the thing is he wants to get in and get out. He wants pre-approval from the court to withdraw on this case. That's what he wants. Because he's already agreed to represent her in all aspects of the case, but he only wants it for 60 days, which means he wants to file his motion to withdraw before he files his appearance. That's what this is. He wants to be able to get out and well, actually, we'll see later on. This not resolved before the expiration of 60-day period may agree to continue representing Miss Owens for additional periods of time. You know what we call that? An appearance as counsel of record. Until you file your motion to withdraw, you know that the court's going to be hesitant to allow you to withdraw. So again, you want your motion to withdraw before you file your appearance. That's what you're asking for. So this is totally improper. Even under the limited scope rules, this is totally improper. If the amount of work required by additional discovery requests from the trustee or any creditors becomes excessive, undersigned counsel may terminate his representation of Ms. Owens by filing a notice of termination of the limited scope of... Again, he he just wants to be able to get out. He wants his get out of jail free card before he even files his appearance. Why even do it? Why do it? That's the question. Chat, tell me why Dave G wants to file any sort of appearance for Laura Owens in this case. I mean, this isn't going to get granted. One, he's a necessary witness. His client opened the door, breached attorney-client confidentiality, and made him a necessary witness, as we heard on February 9th. So he's not going to get this. And I would file an objection to this and be like, no, I want to depose this guy. And I can't depose an attorney of record. He needs to withdraw. So before we go through this whole thing of him withdrawing, why don't we actually, better yet, just file an appearance and then start doing your discovery magic. And then as soon as the attorney says, wait, we need him to withdraw because he's going to be a necessary witness, then just withdraw. And then you have your excuse. You have your way out. For the BJs? Yeah, for the BJs. It's as good a reason as any, I guess. Although I have to seriously question whether or not he would be open to such a suggestion from Lord Owens. He's got a weird obsession with her. Now, people have been saying that he's doing it to CYA, which he could be. But I don't know. It's like people that throw good money after bad, or just like dive in, well, I'm already here, so I might as well just make things worse for myself. I don't know. Anyway, so this motion was filed February 12th, which is 3 days after the creditor hearing or the creditor meeting that we just listened to. And I'm not sure if it has been granted or not, or what the status of this is. I'm not diving too much into this case, but anyway, so that's where we are with Laura Owens and Dave G. Are we sure he hasn't been dipping his pen in company ink? We're not sure of anything. All I can say is that as a practicing attorney, it would be ill-advised to do so. And I'm not necessarily going to say that he is, because there's no evidence of it whatsoever. It's possible. I think it's probably more likely he's trying to stave off some sort of repercussions from Laura against him. That's probably a little bit more likely. I mean, the way she threw him under the bus, right? He's doing this, he's doing that, he's doing this. He's probably worried about it. And even if he's not terribly worried about it, you could see him wanting maybe to try to take the reins a little bit from her, so that she doesn't make a bigger mess of herself. But let's see. Do you think that they'll be less likely to suspend him from the bar if he's active? No. The bar's not going to care. If the bar wants to suspend you, they don't care what cases you're on. In fact, they make you write a letter to all of your current clients and say, hey, I have to withdraw. I think they even, some states, I don't know, I've never had to gone through it, but I think some states might even make you say that you cannot practice law and I need to refer you to someone else. If she thought he had money, he would be dumb to think she wouldn't end up pregnant. Yeah. We don't know, but he picked up his second DUI a couple of blocks from her place. So, did he know? I don't know where they live. I don't know anything about that. I'm new coming into this case, and I'm just reading the documents in front of me. You guys all have way more rumors and speculation out there than I do. He's under investigation by the bar for his behavior. From what I hear, I wouldn't believe, or I wouldn't not believe it. I would assume that the bar is investigating things from what I hear. Especially getting tangled up with this whole, I mean, presumably there's a potential that he offered perjured testimony on the stand, knowingly offered perjured testimony on the stand. And that's a big issue as an attorney, or at least not doing your due diligence, right? You have a duty to not offer perjured testimony on the stand. Remember, Laura Owens is being charged criminally with perjury when in a case where he was representing her. So Was he grossly negligent? Was he in on it? Those are all questions that are appropriate for the bar to question him about. And then also the DUI. I mean, if you keep getting criminal charges, you're going to get the attention of the bar. So he posted communications from the bar about it. It's not rumored. You know what? Again, I don't want to say something that I really don't know is actually happening, but I tend to believe you because I feel like I heard that somewhere. So we'll leave it with that. He was singing. Wait, what? He was singing to her like a third base coach during the hearing in 2024. Was he? Man, I feel like I need to go back and catch up on this and then go through those hearings and watch those hearings. But I'm not going to do that today. I have reached my limit for streaming. I'm not even supposed to be streaming today. I did this all for you. But I'm going to redirect you guys over to Excited Utterance. And I'm not sure exactly what she's talking about. And then I will be back here again on Saturday evening and then again Sunday morning. So you get 2 more times for me this week alone. You guys should be blessed. And I will, see you all. Tell Hella if you jump over there that I said hi. And I'll watch the 2024 trial. I'll have to. That's not when I was streaming, though. Is it old news or should I really watch it? Like, should I stream it and watch it or should I just watch it? Anything? Stream and watch? All right. Take care, all. Have a good night.
When I was young, my daddy said, gotta keep one eye open in your bed, 'cause there's a time coming when the devil's gonna come for you. So my trigger fingers stay prepared. I've got my weapon and I got my prayers, 'cause if you don't run this town, they'll walk all over you. Run out loud, gotta run on, keep on running till the sun goes down. Run out loud, better run all day till you can't be found. Run out loud, gotta run on, keep on running till the sun goes down. You can outrun the devil, but you ain't